How do you actually get a divorce in Australia? Can your ex change your child's surname without your permission? And what do you do when your ex simply ignores court orders? 3 questions, real answers from an Australian lawyer. Let's go. Question 1. How do you actually get a divorce in Australia? Well, Australia has a no-fault divorce system, which means the court isn't really concerned with who caused the breakdown of the relationship. You don't need to prove infidelity, bad behaviour, or fault. The only question is whether the marriage has broken down irretrievably, unfixably. I don't think unfixably is a word, but you understand what I'm saying. And that is established by 12 months of continuous separation. You must also satisfy the court that there is no reasonable likelihood of reconciliation or fixing the relationship. So in simple terms, the relationship is over in a real and practical sense. Most people assume separation means living in different homes. But legally, you can be separated while living under the same roof, but it requires additional evidence to prove that the relationship has actually ended. So the application is filed in the Federal Circuit and Family Court of Australia under the Family Law Act of 1975. You must meet jurisdictional requirements such as being an Australian citizen, living here, or having lived here for at least 12 months. If there are children under 18, the court must be satisfied that proper arrangements are in place for the care, welfare, and development of the kids. That does not mean that everything is finalised. It means that the court is satisfied the children are being looked after properly. This may surprise you, but there are some pretty terrible parents out there. So the actual process is pretty straightforward. File the application, serve the other party, if required, and sometimes attending a short hearing. But this is the part that most people misunderstand. Divorce only ends the legal marriage. It does not resolve property, and it does not determine parenting rights. Custody. In practice, divorce is often the easiest part of the entire process. It is everything that comes after divorce that people are often not prepared for. So divorce ends the marriage, but it rarely ends the conflict. Question 2. Can my ex change my child's surname without my permission? This one comes up a lot more often than you'd think, and it is almost never really about the name. The short answer is no. One parent can't by themselves change a child's surname without the consent of the other parent or a court order. The court approaches this through the Family Law Act and the concept of the child's best interests. It is not about what either of the parents want. It is about what the outcome is for the child that will be best. In making that decision, the court looks at factors like the child's identity, their relationship with each parent, how long they've had their current last name, and whether the change would cause confusion or harm. If the child is mature enough, their views may also be considered. But there is no shortcut around this. A parent cannot simply complete paperwork and bypass the other parent. Any attempt to do that can be challenged and reversed, and there may be other consequences. In reality, these disputes are usually about something a lot deeper. The name becomes a proxy for conflict between the parents. The court recognizes that, and it approaches these things really carefully. The key idea is this: it is not about parental rights, it is about the child. You do not get to rename your child simply because the relationship has ended and you don't like the other person. Your child is not a pet. Question 3. My ex is ignoring our consent orders. What can I actually do? Well, if your ex is ignoring court orders, you're not dealing with a misunderstanding. You're dealing with a breach of a court order. The way that you can address that is a contravention application. This brings the matter back before the court and asks the court to enforce its own orders. That is the correct pathway, not yelling at them or sending abusive messages. That is going to really hurt. It's also just not appropriate. So the court has a range of powers once a breach is established. It can enforce the existing orders, it can vary the orders, and it can impose penalties depending on the seriousness of the conduct. This is not symbolic, it has real consequences. Those consequences can include make-up time with the children, financial penalties, and costs orders. And in more serious or repeated cases, the court can impose imprisonment, which is rare, but it is available. So to succeed, you need to establish that the order existed. That's usually black and white. You need to establish that it was breached. That becomes a little bit more complicated. And you need to establish that there was no reasonable excuse. That's the tricky one. Without it, the application will fail. The court will distinguish between genuine inability to comply, for whatever reason, financial or something else, and deliberate disregard. That distinction is a big one. One attracts understanding, the other attracts consequences. So this is why evidence matters. Communications, timelines, and patterns of behaviour are all critical. The clearer the evidence, the stronger your position. And this is the point most people need to hear. The authority to enforce those orders, that comes from the court, not you. Do not attempt to enforce them yourself. This will almost always make your position worse. An order has power, but only if you use the system designed to enforce it. If you have questions like this, drop them in the comments below. I'll keep breaking them down so that you actually understand how our system works.